The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, ladies and gentlemen, or lady and gentlemen. Judge Harris and Judge Shedd and I are glad to be here with you today and looking forward to your argument. The case is 20-4028, United States versus Robertson. And Mr. Hill, you may proceed.
Thank you, Your Honor, and may it please the court. As laid out in the briefs, three fundamental categories of error require reversal of this case. Once again, the first one that I'll address is the district court's imposition of a 480-month sentence resulting from the application of a 187-month upward variance. It was both procedurally and substantively unreasonable under United States versus Gall and Provenance and other progeny of this court. The two other categories of error that I'll get to involve pretrial rulings around recusal and severance, and mid-trial rulings regarding evidentiary matters, jury instructions. With regard to the sentence, in the pre-sentence report, the guideline range was calculated based on an offense level of 38 and a criminal history category of 1 for zero criminal history, giving rise to a range of 235 months to 293 months. That offense level of 38 included an 18-level upward adjustment for the magnitude of the loss, as well as adjustments for obstruction of justice and no credit for acceptance of responsibility. At sentencing, the district court upwardly varied, as I mentioned, by 187 months, stating as follows as the basis for a variance in the judgment in this case at Joint Appendix 5403. The court finds that the defendant's blatant dishonesty, use of important relationships, callous disregard on the effect his scheme had on others, and the horrible effect his actions have had on a large number of victims warrants a sentence above the guideline range. Okay, so that's the district court announcing a decision to upwardly vary. The very next portion of the judgment is the district court announcing the magnitude of that, the degree of that variance. The court went on to say, the court also finds that a sentence of 40 years is necessary to protect the public from the defendant and deter others from engaging in similar crimes, implicating statutory sentencing factors under 3553A2B for protection of the public and 3553A2C for deterrence. The fundamental problem that is a procedural and substantive unreasonableness issue is that under this court's line of authority as stated in United States versus Blue and Province, the district court must adequately explain the chosen sentence to allow for meaningful appellate review and promote the perception of fair sentencing in order to satisfy the requirements of procedural reasonableness. And as the court said in Provence, where the variance is a substantial one, and here was 187 months, the appellate court must more carefully scrutinize the reasoning offered by the district court in support of the sentence. And the farther the district court diverges from the advisory guideline range, the more compelling the reasons for the divergence may be. The problem with the district court's approach here is that no specific explanation was provided by the district court for the degree of the variance. The two issues stated were protection of the public from the defendant and deterrence. Well, with respect to protection of the public from the defendant, We established at sentencing that Mr. Robertson had no criminal history. And as Dr. Keller, the clinical psychologist offered by the defendant and accepted as an expert by the district judge testified, based on her evaluation of him, he posed a low risk of recidivating.
Counsel, it's Judge Harris. Can I just ask you, I feel that there are sort of two separate arguments you could be making, and I want to make sure I understand which it is. One, and this is sort of what I took away from your brief, was that under Gall, it's not enough to have justified the 40-year sentence. The district court has to have sort of expressly recognized the extent of the variance and explained why that particular amount of a variance was necessary in this case. That would be one argument. The other argument would be, look, this is just a really big variance, and the explanation I see in front of me for 40 years is not good enough. So, or maybe you're making both arguments.
Yeah, well, Your Honor, I would submit that I'm certainly making the first argument, that in order to comply with Gall, with Blue, with Provence, and even following this court's recent decision in Nance, a particularized explanation of the degree of the variance is required in order to give this court an opportunity for meaningful appellate review.
Okay, that's what I thought you were arguing. I just want to press on that a little bit. You pointed us to the part in the transcript where the district court says, I believe the seriousness of the offense here requires an upward variance. Would it satisfy the kind of the rule that you're sketching out if the court had gone on to say, I believe the seriousness of the offense requires an upward variance of roughly 14 years from the top of the guidelines. I recognize the extent of that variance, but I believe it is justified. Is that what you're looking for?
Those are the types of explanations that I submit would be required in order to satisfy the procedural reasonableness requirements, because it's those types of explanations from the district.
By the way, this is Judge Shedd. Isn't that completely implicit? He didn't say I'm going to depart and I'm just going to pluck 40 years out of the ether. He named all the reasons and justified it, and then he picked 40. You think he just picked that number at random? Isn't it implicit that he didn't think anything short of that would be enough? Isn't that implicit?
It may be implicit, and it may be what somebody reading the transcript may derive. But we submit that what is required is for the district court to actually explain why it is that 480 months in particular is
let me ask you
necessary.
this. But let me ask you this. What if the district court had said, for all the reasons listed, I thought about 25 years, but that's not enough to meet the purposes I have in mind. I thought about 30 years, that's not enough. I thought about 35, and just repeat that and explain. He doesn't do it this time explicitly to say that's not enough, I'm giving 40. So in other words, would you be satisfied if he just made explicit what appears to be implicit, as you say in the transcript?
Well, I wouldn't be satisfied with just that recitation, the hypothetical, Judge Shedd, that you related, because it lacks an explanation for why each of those stages were not adequate, but no greater than necessary as required by the statute.
But if each time he said, I thought about 25 under these factors that I've laid out, how serious it is, you just reiterate the same factors and say 25 is not enough because it's so serious. He would just restate everything he stated and said, for that reason, 25 is not enough. I thought about 30, but for the very same reasons I gave 40, I'm telling you, that's not enough. That would be enough. That would be enough for you, for us to then be able to affirm it.
I'm not sure that would be enough, Judge Shedd, if I understand what you are positing, because what is required is a sufficient explanation of the district court sentencing rationale, and in this case, segmented down into the steps from, for instance, the guideline range of 235 to 293, and then moving up to a level 262 to 327 months. And what we submit is that the district court would need to articulate so that this court may review and understand what it is that the district court is doing with that.
Mr. Hill, this was a jury trial. Can Judge Gibney rely on what he heard as a basis for what he said in the at the time of sentencing? Can we not imply that?
Well, I believe that the district court can rely on what he has heard during the trial, just as in sentencing, the district judge is not bound by formal rules of evidence. But again, it's not the input that is problematic here. It is not what it is that Judge Gibney considered or didn't consider. The problem is that in the way he announced the sentence, he failed to provide this court with sufficient information to understand it so that this court could then, as required by Provence, apply that more careful scrutiny given how far the district court had diverged from the advisory guideline range.
Counsel, it's Judge Harris. Let me try to get some clarification on something just for myself. I hear what you're saying about, we've said many times, the purpose of the explanation is to give us a sufficient basis to review the substantive reasonableness of a sentence. I have to say, in reviewing this transcript, I do feel like I understand why the district court sentenced the way he did. I mean, he obviously thought the offense was incredibly severe and that the guidelines sort of undercounted the degree of harm that this defendant had done in his community. There's another reason I could imagine, that language from Gall, that you might want a district court to expressly acknowledge the degree of the variance, and particularly in a case where the variance is so large, which would be that you might worry, maybe the district court didn't even understand how far up he was varying. Like maybe this was, are we 100% clear he got the extent of the variance? I could imagine a case where that was a concern, but when I look at the transcript in this case, it just seems 100% clear. I mean, it's the second time around. The district court obviously understood the degree of the variance in this case. And so I guess I'm coming back to, I think, some of Judge Shedd's questions, sort of what is functionally added here if we make the judge go through the steps of saying, I considered adding 12 months. That didn't seem sufficient for the reasons already given. It's a very serious offense. Then I thought about, I suppose you would let him do it year by year. Would it have to be month by month? I'm just not sure what's added functionally.
Yes, Your Honor. I think what's added functionally is a tethering by the district court of the information that the district court has gleaned from the trial and from the sentencing proceedings in order to inform where the judge thinks the sentence will wind up, whether the guidelines are above. But then it'll tether that information to the actual sentence that's pronounced with the variance through the lens of the statutory factors. In other words, here, the district judge articulated, again, protection of the public and deterrence. Well, we briefed both issues. As to protection of the public, we have the unrebutted testimony of Dr. Keller. We have the information from the sentencing guidelines. With respect to deterrence, if we look to the sentences reflected in the pre-sentence report handed down for instance, the investment fraud co-defendant Sherman Paul Vaughn, his sentence was 144 months. Well, deterrence was obviously a factor necessary for the district court to consider in sentencing Mr. Vaughn for the investment fraud conduct. With respect to the bank fraud counts, defendants Marlon Hardy, Frederick Davis, et cetera, I think the highest sentence that they received was 71 months for Frederick Davis.
Well, Mr. Hill, let me ask you this. Insofar as that substantive reasonableness argument or disparity argument, Vaughn really isn't similarly situated, is he? I mean, he wasn't involved in the loan frauds. He pled guilty. He agreed to cooperate. I mean, is that enough to distinguish the difference between Vaughn's sentence and your client's sentence?
Well, I think if the court looks to the degree with which Vaughn was engaged and set up the investment fraud, I see that my time is up.
You can finish your answer.
Thank you, Your Honor. I think if the court looks at the trial testimony of Vaughn, in which he acknowledged that he set up the Cavalier Union investment vehicle, that he set up the promissory notes themselves in the documentation, that he tasked Mr. Robertson to go out and acquire participants and investors, then they would be more closely situated than they would be different.
All right. Thank you, sir. You have some time in rebuttal.
Judge
go ahead, Judge.
Can I ask one question?
Sure.
Mr. Hill,
Yes, sir.
let me try to get through this quickly. Would you agree with me that we could be reviewing a sentence in which there doesn't appear to be any procedural error, and up to the point of the putting the number of months in the sentence, everything looks fine? Are you with me in this hypothetical? So you can't point to any flaw in the court's procedure on their analysis up to the point of the imposition of months. You understand what I'm saying?
I think so, Your Honor.
And then do you agree with me, or at least there seems to be, then some number, which if it's imposed on an otherwise proper sentence, would just be so far beyond the pale that the sentence would be substantively unreasonable. Do you agree with that?
Yes, Your Honor.
All right, that being the case, let me ask you this question. And by the way, I wanted to ask you because I'm going to ask the government the same question. And I thought it's fair to let you answer it, and then we'll see what they have to say. If, in fact, just hypothetically, I know you aren't conceding anything, but if a reviewing judge or reviewing court were to believe that everything the judge did up to the point of imposition of months was procedurally and substantively reasonable, what number of months in your estimation on the analysis could be added to this sentence? What would be the longest sentence that could be imposed if procedurally and substantively otherwise everything's fine? What would be the outermost number of months under your analysis that could be given in this sentencing?
Well, Your Honor, if I understand,
I think you do. If everything about the sentencing is fine, and we're only considering the actual number of months, what number of months do you think is that could be imposed on an otherwise completely proper sentencing procedure? In this case, what would it be?
Well, I would say that something less than 480 for sure.
I know that, but I'm asking you pin it down better if you can. If you can't, using the analysis we have to apply under the law, I'm just asking. By the way, you don't win or lose your case on this as far as I'm concerned, but I just want to know your insight into the analysis that has to be applied. And I'm going to ask the government the same thing.
Yes, Your Honor, and I would say that, and my apologies for not answering it right away, but to get there would be an incremental. It would be an incremental exercise, and so
Let me say this much. I'm satisfied if you want to get back up and reply and answer it. I'm satisfied.
Okay. Thank you, Your Honor.
All right. Thank you, sir. Ms. Martin.
Thank you, Judge. May it please the court. Merrill Robertson's second trial was fair. His convictions for defrauding investors and financial institutions were again supported by overwhelming evidence, And the district judge in this case, having heard the evidence twice, imposed a substantial sentence, but one that was both procedurally and substantively reasonable. Now,
Counsel, Counsel, can I just ask you, what is the government's position on the appropriate sentence for Mr. Robertson? At the first sentencing, you asked for the top of the guidelines. It wasn't really clear to me, the government's position at the second sentencing. Do you now think that 40 years is the more appropriate sentence, not 24?
I think, the court made a recommendation at Mr. Robertson's first hearing, and then at the second hearing, I think what the government argued was that if the court was inclined to impose the same sentence a second time, that it was substantively reasonable.
Right. No, I read that, but I guess I'm asking a slightly different question, which is, at the first sentencing, the government's position was that 24 years, give or take, would be the appropriate sentence. And I'm just wondering, is it the government's position now that, look, we think 24 years is right, but we can't say 40 years is substantively unreasonable, or is the government's position 40 years is the right sentence?
So I think it's correct to say the government did not move for an upward variance in the case, but also acknowledges that reasonableness is a range and not a point. So whether or not the government or this court might have found a different.
This is Judge Shedd. Would you answer a question though? What's the government's position? Is it that 24? No, the 24 is the right number. You think the right number, but you concede that the government could go higher. It's within his discretion and it's not reversible. Which is your position?
That's the government's position, that it initially recommended 24 years in its estimation, the high end of the guideline range, but that the court's sentence that it imposed was substantively reasonable.
But Ms. Hill, from your experience, how does Robertson's sentence compare to other first-time nonviolent offenders with similar criminal offense levels? You have some experience in that area?
Well, I think it would be very difficult to compare Mr. Robertson to another first-time fraud offender because, of course, the court has to conduct an individualized assessment of each defendant. And here, that's exactly what it did. It, throughout the sentencing hearing, considered factors that were already accounted for in the guideline range to support its sentence outside of the guideline range. So, for example, Judge Floyd, the court noted that the guideline range, of course, in most fraud cases are driven by the loss amount under 2B 1.1, and that and so Mr. Robertson an 18-level enhancement for the loss in this case, but the court noted that that's just a number and it doesn't account for what that loss meant to the person who lost it. So it talked about, right, that a $10 million loss to Bank of America, who might not be affected by that level of loss, is very different from a $100,000 loss to somebody who that was their entire life savings. And the court made clear that in particular was an aggravating fact of this case, that the loss was spread across more than 60 people, and for most of them, it changed the outlook of their entire life. The court also noted that the loss table doesn't account for the kind of money that's stolen. So in another fraud case, right, you could have the same loss amount, but it was just somebody lost their salary. Here, Mr. Robertson particularly, yes, Judge Harris.
I'm sorry, counsel, I appreciate the explanation, and I thought the district court was quite clear in sort of the court's response to the nature of these offenses and how much it had harmed the victims. I guess I'm not trying to give you a hard time about the government's position. It's just that under Howard, one of the factors we look at in determining whether a sentence is substantively reasonable, and it's absolutely not dispositive, but we do care if the district court has varied a lot or at all above what the government is asking for, sort of on the theory that, look, the government sees a broad sweep of these cases and it comes into court and it has a good sense of where this case is in the range. And so just sort of going back to Howard, how troubled, how concerned should we be that it sounds from what you're saying today that although the government thought 24 years would be a fair sentence, and it has that kind of broad perspective on a range of cases, the district court varied so substantially over the government's recommendation?
So I don't think that should give the court pause, because I think this court's jurisprudence makes clear that, again, even if this court, even if the government might find a different sentence reasonable, that is not a sufficient justification.
Right. I'm asking you what I should do with the fact that the government found a different sentence reasonable. I totally understand that, and we say this in Howard, the mere fact that we would come up with a different sentence counts for nothing. But the fact that the government came up with a much lower sentence is supposed to count for something. So I guess I'm just asking you to tell me how to factor that in under the Howard analysis in this case.
Yeah, and again, I think the answer to that is that that reasonableness is a range and it's not a point. Now, is there a significant range between 24 years and 40? Sure, but the question is, did the court have a reasoned basis for exercising its own legal decision-making authority? And I think it did. I think it's clear that that the reasons for imposing that sentence were that it had sufficient reasons to impose that sentence.
Ms. Martin, this is Judge Shedd. Let me ask you this, a couple questions. First, didn't the district court believe it was at least trying to treat the two defendants the same way, because he talks of doubling the bottom of their guideline range in each case? Isn't that correct?
Yes, that's correct.
He did. So at least he tried to come up with some rationale for what he did. Now, I want to ask you sort of the line that I asked Mr. Hill. You do agree with me, I'm asking you if you agree with me, that a sentence imposition could be procedurally and substantively reasonable through the whole process, down to the number of years or months imposed. Do you think that then at that point, just looking at the number of months imposed, that by itself could make the sentence substantively unreasonable? No other errors, just the actual number of months. Could that make a sentence substantively unreasonable in and of itself?
If the number of months was not. I'm just
asking, is that possible?
It's possible if the number of months, if there's not a
all I needed is a yes or no. You think it can, right? For instance, let's say, just in this case, if he got to the end of this sentencing and you would argue there are no errors to that point, and he said, I'm sentencing you to 150 years, that would make this substantively unreasonable, don't you think?
150 years in this case, I think, would be substantively unreasonable. Yes, Judge. Okay.
All right. So let me ask you, what do you think is, under the facts of this case and under the sentencing of this case, it's the same question that I asked of Mr. Hill. What does the government think is the maximum sentence the court could have given in this case under these facts, under this sentencing procedure?
I think the court could have substantively justified a sentence higher than it imposed, but I certainly think.
I know I'm asking, but the same thing I asked, what number do you have under your analysis? Do you have a number?
I don't have a number.
The outermost limit?
I certainly know that there are cases, Judge, after the Richmond division where judges have imposed fraud cases for first-time fraud defendants a sentence of 100 years, and that was in the Oken case. So wait a second. Wait.
Are you saying in this case you think the government's position is 100 years in this case?
I'm not saying that the government's position is 100.
But I'm asking you about I'm asking you about this case. I just want to understand your analysis. Have you done the analysis in your own mind or preparation to think of what number might be the outermost point at which the government would have to say to us, we think that in and of itself is unreasonable?
Well, candidly, Judge, I haven't thought about what the outermost limit would be because I don't get to impose the sentence, but I do.
But you get to answer my question.
No,
you get to answer my question.
Well, I mean, I think that my answer is I think that the court could have imposed something more than this. The court could have imposed 50 years, and I think that could have been a substantively reasonable sentence in this case. But I also think that a sentence of 40 years is substantively reasonable, and it's
no. I can cut this short, I think. So you think that the court could have imposed a number greater than 40 years in this case without making it substantively unreasonable, correct?
That is correct.
Ms. Hill, let me ask you this question as a follow-up to Judge Harris and Judge Shedd. The problem that we face is you guys put us in knots. Our goal is to try to affirm the district court if we possibly can. And what we're trying to figure out is where is that range short of 40 that is reasonable?
I mean, whether 35 would have been reasonable. Again, I think this court's jurisprudence is clear that it's reasonableness is a range. So there isn't an exact number that I think we could all agree on. Well, this 38 years, that is the perfect number that is supported by all of the evidence in this case and is a sufficiently reasonable sentence. But I think the question is, did the trial judge have a sufficient basis for the sentence that it imposed? And I think it is clear on the record that it did.
Counsel, can I take you back to Judge Shedd's question about the part in I think it's the recusal hearing, where the judge suggests that the way he got to 40 years was by doubling the bottom end of the range. And you apparently read the record the same way. We think that's how he picked these sentences. He doubled the bottom of the range for each defendant. Is that a good way to pick a sentence under 3553A? I was sort of surprised to see you embrace that. I think if we had a case where the district court, it's clear that he varied upward by 14 years by doubling the bottom end of the range without actually considering whether the product of that equation was suitable under 3553A, I think we maybe have a problem.
Well, I think that the thing is that what is clear from the record and what is clear from this sentencing hearing that lasted, 166 pages of transcript is that the court just didn't cavalierly say, okay, 235 times 2, there's my sentence. That's not what it did. It absolutely considered. Well,
I thought you told Judge Shedd that is what it did, that it treated the two defendants the same way because it doubled the bottom range for both of them. And the judge does sort of suggest that was the method in the recusal hearing.
Well, I think what I was acknowledging was that the outcome for both of them, 144, was the doubling of the bottom of Mr. But not that's how he, that's all he did to arrive at the sentence that he imposed. And I think it's clear from the record that that's not what he.
Well, if he did what Judge Harris is suggesting to you, and which is in the record, isn't that tantamount to flipping a coin?
I mean, no. Again, I think it's clear that that's not what he did. It's a comment that he made in the recusal hearing, but in the course of the sentencing hearing in this case, he analyzed every single statutory sentencing factor. He actively engaged throughout the sentencing hearing with the parties, with witnesses, with victims. He actively engaged with the defendant during his allocution. He addressed the defendant's particular arguments that were aimed at a guideline range sentence, all before he acknowledged what the guidelines were, and then indicated that an upward variance was warranted?
It isn't your answer that he did not use that doubling as justification for what he did. He explained that as you're saying otherwise, but when he's being questioned about recusal, he points out he is not punishing this person or is not treating Mr. Robertson differently, because what he's done is basically treated both of them equally on that scale. Isn't that what that's all about?
I think when I was responding to your question, Judge said...
isn't that what that's all about, his comment about I've doubled both of them? Wasn't that an effort to show that he did not have any animus toward Mr. Robertson? Am I wrong? Or is that what he did?
I think it is right to say that it was his effort to show that the extent of the variance was comparatively the same for both of them.
In an effort to disprove a claim that he had a bias toward Mr. Robertson.
That's correct, Judge.
Anything else?
If the court has no other questions on this topic or any of the other issues raised, the government would rest on its papers.
Thank you, ma'am. Mr. Hill, you have some reply. You're muted.
Thank you, Your Honor. Let me touch briefly, if I may, on the sentencing issue and the recusal issue as they intersect. It was just touched on. What we have in this case is the procedural and we believe substantive unreasonableness of the sentence intersecting with the appearance of impropriety or suspicion of partiality issue that we raised in the papers. And so it's a twofold problem because the district court, in our view, didn't sufficiently explain the basis for the 40-year sentence. It appears to be the same sentence that was handed down the last time after a different trial. What we're looking at now, in line with Hathcock versus Navistar, is this. Under that case, the court stated the question is not whether the judge is impartial in fact. It is simply whether another, not knowing whether or not the judge is actually impartial, might reasonably question his impartiality on the basis of all the circumstances. And since we have a situation here, as outlined in the brief, with the mid-first trial revocation of Mr. Robertson's bond, with the comments regarding his character that made its way into the papers, the 40-year sentence after the first trial, which was challenged for procedural and substantive reasonableness as well in the first appeal. And now the second trial with the exact same result and an insufficient explanation for the degree of the variance.
Mr. Hill.
Yes, sir.
Let me ask you this. If I remember the record correctly, the judge said something like this. I've been on the bench about 8 years, and this is the most explanation I've ever given in a sentence. Now, let me ask, I think I'm correct on that. If that's the case, do you think the judge in imposing this sentence is incapable of understanding the law as to what he's supposed to do? Or is he just incapable of expressing himself? Which do you think it is?
Your Honor, I don't believe it's either. I wouldn't call Judge Gibney incapable of understanding the law or incapable of expressing himself. And I don't know why the district judge in this case articulated the sentence and didn't articulate aspects of the sentence in the way he did. I understand.
I know, but I know this, but you agree with me, don't you, that he said something basically like this: "This is the most I've ever explained a sentence." Didn't he say that? Do you remember?
I don't recall specifically, but what
I think he said this is. Let me say, just take it then as a given for my question. If the judge goes, this is the most I've ever explained the sentence, then you would think, while he said a lot, he didn't know what he was supposed to say to support the sentence.
Well,
Correct.
All I could say, I'm not a mind reader. I wouldn't presume to read the mind of a district judge, but all I could
you don't have to be. You don't have to be. I think I'm quoting pretty much directly from the record. You don't have to be a mind reader.
Yeah. Yes, Your Honor. But in terms of taking the next step and assessing why it was that the district judge didn't comply with what we believe the clear requirements of Blue and Provence and Gull to be, I don't know. What I submit to the court is that, in our view, he did not, and that rendered.
I know you. Your argument is he didn't. Have you come up with the number for me that you think is the outermost number that could have been applied in this case if everything else is fine? His analysis, his factual determinations. I know you don't agree with that, but if you accept that for purposes of my question, then do you have a comment for us on what the outermost limit? The government had a little bit of a problem, but do you have one?
I do not, Your Honor, and here's why. Okay. As an attorney, I don't have to make those calls. District judges do, and they're very difficult.
I know this, but if I asked you to, you should.
Yes,
but
sir.
If you say you just don't want to, because see, I'm not asking you to peg your client down. I'm asking you, under your analysis of the law and what he said, what do you think the number should be? Is it the top end of the guidelines? Do you think under these facts he could have varied at all above the top end of the guidelines? Or you don't want to answer that question?
Your Honor, what I would say is that we submitted at the sentencing hearing that Mr. Robertson would accept a high end of the guideline sentence. I believe that's what we submitted. So,
but that's a different question I'm asking you. You understand?
Yeah.
I'm sorry.
And counsel, I don't want to. I want to follow up on this question, and I want to be clear. I'm only talking. My question is only about procedural reasonableness. I had sort of assumed your position was, had your client been sentenced within the guidelines, this explanation would have been procedurally sufficient. But is that not correct?
Your Honor,
arguing that?
I think that given the teachings of Provence, with the greater explanation needed for a greater variance from the guidelines, I would agree with that. Yes, Your Honor.
Okay. And so if it had been just 1 month over, like would this explanation have been sufficient procedurally? I'm not talking about the substantive reasonableness, but would this explanation have been sufficient procedurally to support a very small variance?
Your Honor, I guess I would say that in my view, it probably would be, particularly since the probation officer noted in 130, paragraph 130 of the PSR, that the probation officer had not identified any factors that would warrant a departure from the applicable sentencing guideline range. So if the actual sentence imposed by the district court were only a matter of a 1 month variation from what it was that the probation officer calculated and recommended, and in line with what the government had sort of offered up at the first trial, and what the defendant himself through counsel had offered to the court to be the appropriate sentence in this case, then yes.
Okay, so it's not like an on-off thing. You're not. That's helpful. So the problem for you is that this explanation doesn't match up with a variance this large, but not that it couldn't have supported a smaller variance.
Yes, Your Honor.
Okay.
All right, thank you. Judge Shedd, do you have any further questions?
I do not. Thank you, Judge Harris.
Judge Harris? Any further
thank you.
questions? Oh, well, I want to thank Ms. Martin and Mr. Hill for your arguments. We appreciate your candor and, as I said, the argument here today. As you know, normally we would come down and shake your hand and greet you. if we were in Richmond, but unfortunately we're not there, although we'd love to be. But nevertheless, understand that we very much appreciate your service to the court system. Case is submitted, and the court will take a brief recess to conference this case and then reconstitute the panel.
This honorable court will take a brief recess.
Judges, I'm going to place you into the
to our Friday afternoon session with 2 cases left on the calendar this afternoon for hearing. First up is United States versus Mayhew. Mr. Corzine, I understand you have some counsel to introduce to the court, so please proceed.
Yes, thank you. May it please the court, Judge Diaz, Judge Floyd, Judge Harris. My name is John Corzine, and as director of the Wake Forest Appellate Clinic, and under Local Rule 46A, it's my pleasure to introduce the 2 student counsel who will be arguing for Appellant David Mayhew. First, I would like to say we greatly appreciate this opportunity for experiential legal education, especially during this terrible pandemic. So really do appreciate that. The counsel today for Mr. Mayhew, first is Caitlin Augerson, who will be addressing the first issue on plea advice. And second is Catherine Batchelor, who will address the 2 issues about restitution. For rebuttal, there was only room on the form for 1 person, and we do have Ms. Augerson listed. If Ms. Batchelor has points you'd like to make about restitution, or the court has questions about restitution, I hope there could maybe have some indulgence for one or both to address the particular issue and stay in their lane during rebuttal. But again, thank you very much for this opportunity.
Thank you, Mr. Corzine, and we very much appreciate your school and the students taking on this case and helping the court with the matter. I look forward to hearing argument. And we'll begin this afternoon with Ms. Augerson.
Good afternoon. May it please the court. My name is Caitlin Augerson, and on behalf of David Mayhew, I'm going to address the first issue. Mayhew's 6th Amendment right to effective counsel was violated when his trial counsel advised him that he would receive a sentence between 2 and 5 years imprisonment if he was convicted, but he received a sentence of 26 years. Under the Strickland standard established by the Supreme Court in 1984, ineffective assistance of counsel requires a showing of both deficient performance and prejudice, and Mayhew meets both these standards. Starting with the first prong for deficient performance, a defendant is entitled to relief when the misadvice of the lawyer is so gross as to amount to a denial of the constitutional right to the effective assistance of counsel. As this circuit saw in 2020 with Dodson against Ballard, where the defendant in Dodson alleged counsel's misunderstanding of the law, which led the counsel to advise the defendant not to plead guilty, and the defendant was ultimately convicted at trial and sentenced to life imprisonment when he had a plea offer for 1 to 10 years. This court held that counsel rendered deficient performance when he misadvised the defendant about the elements of statutory burglary offense and the strengths of the defendant's case, and the defendant suffered prejudice from such advice. Just as this court found that based on the counsel's deficient advice, which reflected his lack of knowledge of the pertinent law, the court concluded that counsel's performance was constitutionally inadequate. Similarly here, Mayhew's counsel provided such gross misadvice as to tell him that he would receive a maximum of 5 years if convicted at trial, but ultimately ended up with 26 years in prison.
Ms. Augerson, can I go ahead, Judge Harris.
No, you go. Go ahead, Judge Diaz. I'll bet it's the same question.
So, how do you think? What do you think Mr. Mayhew thought with respect to this alleged misadvice? Do you think that he was misadvised as to what the maximum sentence was, or as to what his potential exposure was given his particular circumstances, including any potential enhancements or mitigation factors?
Your Honor, Mayhew was misled and misadvised as to not only the maximum of what he would receive if convicted at trial, but the possibilities of consequences if going to trial. He didn't have the opportunity to make a fair judgment based on the plea offer that he was given, which was a 0 to 5 years, and what he was told would be his maximum or just general possibility if convicted at trial of 2 to 5 years.
Okay, so let me stop you there. So with respect to the maximum sentence, if that's sort of the misadvice here, wasn't that effectively cured by Judge Fox's fairly careful recitation as to what the maximum sentence was for each of the counts that Mr. Mayhew was facing?
No, Your Honor, it was not cured at the arraignment hearing. While the government has argued that this was that has argued with case law that only looked at Rule 11 hearings, an arraignment hearing does not provide the same colloquy that is seen in a Rule 11 hearing.
Well, that may be true as a general sense, but this was a fairly detailed hearing. The judge went down the litany of counts that Mr. Mayhew was facing, and in fairly good detail explained to him what the maximum sentence was for each count. And then on top of that, he made it very clear to Mr. Mayhew that whatever advice or estimate his lawyer may have provided as to his potential exposure was just that, an estimate, and that he was ultimately the sentencing authority, and he would be the one who would impose sentence in this case. Now, it may be that Mr. Mayhew wasn't paying attention because he was distracted by some other things, but the question is whether or not a reasonable observer in these circumstances would have thought that that cured any potential misadvice. So what's your take on taking all of the circumstances in this case? Why isn't this effectively cured by the judge's careful recitation in court?
Your Honor, counsel's misadvice was not cured by the simple recitation of the possible sentences, or just the general information that was given by Judge Fox during the arraignment hearing. The general statements as to informing Mayhew that yes, his counsel's estimates were just that, an estimate, is not enough to say that he was told that 2 to 5 years. 2 to 5 years.
Well, you don't think, Ms. Augustin, you don't think a reasonable person would have, if he'd been paying attention, would have said, now, wait a minute, my lawyer told me, he guaranteed me 5 years, no more than 5 years, and the judge is telling me that that's just an estimate. There's no guarantee of anything. It would seem to me that would put somebody on inquiry notice that there's a disconnect there. Maybe I ought to pipe up and say something.
Your Honor, Mayhew did express multiple times his concern with his counsel and his concern with the lack of preparation that had been done prior to the arraignment hearing, as well as the fact that he didn't even know that he was going in for an arraignment hearing for the day before trial. He had expressed that extreme concern that counsel had not given him the appropriate information and guidance ahead of time. But given the circumstances,
Ms. Augustin, how should we interpret the counsel's unwillingness to sign that affidavit that your client filed in this case?
Your Honor, as you noted, Mayhew drafted an affidavit, and while counsel did not sign it, counsel also did not provide a contradictory affidavit. And under the North Carolina Bar Association's formal ethics opinion from 2011, counsel had full ability and full right to write and sign their own contradictory affidavit. And they failed to do that, and they failed to provide any contradictory evidence of any sort. So while counsel did not sign this affidavit, they also did not provide anything to contradict the statements that Mayhew had made.
Counsel, I just, in terms of where that leaves us, I understood your brief to be maybe arguing that we could find ineffective assistance on the record in front of us rather than sending it back for a hearing, but there's nothing in the record that proves that the counsel actually said this, the 2 to 5 year thing. So wouldn't the most we could possibly do be to send this back for a hearing to find out what actually happened?
No, Your Honor. The fact that there is no contradictory evidence from counsel or any information that would go against the statements that Mayhew has made, there is nothing to contradict his assertions or the statements. There therefore is enough for this to go back for resentencing. However, as you noted, if this court does not find that there is enough information in the record, Mayhew is at the very least entitled to an evidentiary hearing. In United States versus Hall from this circuit in 2019, on appeal, this circuit noted that the defendant in that case submitted an affidavit complaints about the advice he had received from trial counsel. However, in that case, the trial counsel had in fact submitted a contradictory affidavit.
Ms. Augustin, can I ask you a question related to what Judge Harris just asked you? So what is the competent evidence with respect to the allegations related to the guarantee. Is there an affidavit in this record from your client?
Mayhew has drafted an affidavit on behalf of counsel. However, as we noted, that was not signed.
No, I'm asking you whether Mr. Mayhew ever signed something under oath saying I was given advice as to a guarantee.
Your Honor, I see that my time is almost up. May I answer your question and conclude?
Yes, please.
Mayhew did file a pro se motion to reconsider 3 months prior to sentencing. And in this motion to reconsider, he stated his extreme concerns with counsel, and he did state that he had been repeatedly told this 2 to 5 year range. In conclusion, we ask that this court vacate David Mayhew's judgment and remand for resentencing, or at the very least, Mayhew is entitled to an evidentiary hearing to establish his allegations. Thank you.
Before we let you get away, I just want to ask if any of my colleagues have any additional questions of Ms. Augerson.
No, sir.
No.
Okay. Thank you very much. All right, Ms. Batchelor, we'll hear from you.
Your Honors, and may it please the Court. My name is Catherine Batchelor, and on behalf of Appellant David Mayhew, I will be discussing issues 2 and 3. Turning to issue 2, Mayhew.
Ms. Batchelor, can you get a little closer to your mic? I'm having a little trouble hearing you.
Can you hear me now?
Yes.
Better? That better? Okay.
Yes.
Turning to issue 2, Mayhew's ineffective assistance of counsel claim regarding the restitution funds is cognizable under 28 U.S.C. 2255. This result can be reached applying the Supreme Court's jurisdictional analysis from Gonzalez v. Bayer in 2012. In Gonzalez v. Bayer, the Supreme Court interpreted the language of a different habeas statute to determine whether the Fifth Circuit had jurisdiction over Gonzalez's appeal. The Gonzalez court held that, quote, a rule is jurisdictional if the legislature clearly states that a threshold limitation on a statute's scope shall count as jurisdictional. Therefore,
Counsel, it's Judge Harris, and I apologize for interrupting, but we have such limited time. It seems to me that whether or not it's jurisdictional isn't exactly enough to get you where you need to go. Even if we thought this rule were not jurisdictional, do you want to get to the part where the statute's text seems to limit it to cases where someone is seeking release from prison rather than just challenging the amount of money they have to pay? Because even if it's not jurisdictional, it might still be a mandatory rule.
Yes, Your Honor. In February of 2020, the Sixth Circuit in Wagner against the United States actually applied the Gonzalez court analysis to the language of 2255A, and particularly the provision that claiming a right to be released. And the Sixth Circuit court concluded that because Congress has not indicated with sufficient clarity that, quote, claiming the right to be released is jurisdictional, that court should...
Okay, counsel, I think I'm not being clear about my question. I will assume for the sake of argument this is not jurisdictional. A court doesn't lose jurisdiction because someone is not seeking release from prison. My question is, whether it's jurisdictional or not, why is there a cause of action under 2255 if you're not seeking a release from prison and you're only challenging the amount of money you have to pay? I'm assuming it's not jurisdictional, but I want to know why you can go forward. Why is there a cause of action?
Your Honor, well, looking at the case law from the circuit, in 2005, a panel of this court in Lucenhop against the United States allowed a defendant to use a 2255 motion to allege that his restitution order would have been substantially less had it not been for the ineffective assistance of his counsel.
Ms. Batchelor, let me ask you, shouldn't your answer to that question be that the guidelines regarding the restitution were improperly calculated, so it drove the sentence higher?
Yes, Your Honor, yes. And that would fall under, if this court chose to adopt a standard that's suggested by a panel of the circuit in Hudgens in the United States, that a 2255 motion cannot be used for the sole purpose of challenging fines. Here, Mayhew is not alleging a claim of ineffective assistance of counsel counsel that is challenging solely the amount of fines, because he is also challenging how those
But I thought we didn't. I don't think we granted a COA on the issue of the sentence. The certificate here is limited to the issue of restitution alone. Isn't that right? So why isn't that separate issue of sentencing effectively waived here?
Your Honor, I believe that the certificate of appealability was in regard to the restitution sums and not the restitution order, and that inclusion of those particular restitution sums that were the subject of dismissed charges were also included within the range of sentencing for the base offense level. And
counsel, I don't want to tell you how to argue your case, but it looks like what we granted the certificate of appealability on was whether Mayhew's particular claim that defense counsel rendered ineffective assistance in failing to object to restitution sums is cognizable. And I thought Judge Floyd was suggesting that your argument might be that, yes, his claim was cognizable because the failure to object to restitution sums actually affected his sentence.
Yes, Your Honor. Yes, and because the failure to object to restitution not only affected his restitution order, it affected his base offense level because it increased by 2 points. And so the inclusion of those sums from the dismissed charges it raised the base offense level. And the Supreme Court in Belina Martinez against the United States from 2016 has said that has highlighted that the sentencing guidelines play a central role in sentencing, so that any related error is particularly prejudicial, even where, as in a case like the one before us, the judge upwardly departs, that where the starting point was incorrect because of a counsel's failure to, as in this case, counsel's failure to remedy it, Mr. Mayhew was prejudiced because his base offense level started at the wrong spot.
Okay. So if that's your theory, I just have one question. So the petition itself, the 2255 petition in the, I think it's issue 12 that describes this problem, it ends by asking that the restitution order be vacated. Is that a problem, that the relief that's sought under this issue is not a resentencing or a vacature of the sentence, but that the restitution order itself be vacated?
Your Honor, in the pro se motion, while that is a specific ask of relief at the end, the motion also includes the argument about the effect on sentencing guidelines and how it increases base offense level because it should not have been included. So I don't believe that while perhaps the last conclusion in the motion was about the restitution order, that the entirety of the motion is arguing that it also applies to the sentencing guidelines.
So you think we could liberally read this petition, as we should for a pro se petitioner, to be challenging the sentence as well as the restitution order?
Yes, Your Honor. Resolving in favor of the defendant, yes. And because Mr. Mayhew, as counsel, did not object to the sums from the dismissed charges for both the dismissed charges before trial and the amounts from the dismissed charges at trial, it was objectively unreasonable to do so, and his failure prejudiced Mr. Mayhew both in the amount of the restitution order as well as where his base offense level started for sentencing purposes. And so for these reasons, we ask that the court remand for resentencing. Thank you.
Thank you, Ms. Batchelor. Mr. Bragdon, we'll hear from you.
Thank you. May it please the court. I'd like to start by commending my colleagues, the students, for a very excellent briefing and argument in this case. I do appreciate that. On Mayhew's first claim, when we look at prejudice, he has to show a reasonable probability that he went to trial because he was guaranteed no more than 5 years imprisonment. And I say that for a couple reasons. First of all, the alleged error here, and there's been no resolution of whether or not there was any attorney misadvice. So we're assuming that his statements are true because there was not an evidentiary hearing. But when we look at this, the error is not misestimating the guidelines or misestimating the sentence. A number of cases that we cited in our 28J letter established that it's not ineffective assistance to give bad advice about the guidelines. The only error here that's alleged is that the attorney improperly made this guarantee that it was no more than 5 years in prison. And if we assume that that's true, the court corrected that. And we can know.
Counsel,
yes.
Can I ask you a question about the court correcting it? So I know we have all these cases where we say the district court, even where there has been this gross misadvice, the district court fixes it during a Rule 11 colloquy and before the defendant accepts the plea by informing the defendant of his actual sentencing exposure. But there wasn't a Rule 11 colloquy here because the defendant didn't plead guilty. And so he wasn't advised of his sentencing exposure by the judge before he accepted a plea. He was advised of his sentencing exposure after he already rejected the plea. And so I don't really see how those cases address this problem. He had already rejected the plea. There's nothing in the record to suggest that after he was advised that his attorney was wrong, the plea was put back on the table. The government said, now do you want to reconsider? So I don't see how you can fix it. It's sort of like a cat out of the bag problem. How does it fix it if, I mean, he is alleging the prejudicial effect happened at the moment he turned down the government's plea. And the government's own brief very forthrightly says that was the night before the arraignment. That's when that went down. And then the next day, he's given information that maybe convinces him, wow, I might have screwed up last night, but how does that help anything?
Well, Your Honor, I do think the question here is this but-for question of what would he have done if he had received good advice? And he answers that question because even
okay, so should I take from your answer to my question that you are off this point, that you are conceding that the fact that he was advised of his sentencing exposure after he had already turned down the plea sort of washes that element out, and now we're down to this but-for question under Lafler?
I guess I don't separate those 2 points, Your Honor, and if you could just let me explain for a minute. I think that I do agree that this doesn't present the exact same situation that the plea agreement situations present. But I think what it does present is the court gives him good advice. And after this good advice, he says, I still want to go to trial. And let me get the language right. He says, I have every intention of going to trial and want to go to trial. He doesn't say, well, actually, I want to take that plea now. He doesn't say, Your Honor, let us have time to reconsider and take this plea. He gives absolutely no indication that some guarantee had any effect on this. And so the court corrects the advice. He has a chance to say something about it. And the only thing he does say is, I want to go to trial. And so I think that conclusively answers the question of, did this under Lafler, did this make a decision and a difference in his decision to plead guilty, to plead guilty or not guilty? And the answer is no, because he, despite the good advice, he still announces his intent to go to trial and pleads not guilty.
I assume that if there were a hearing, he would come into court and say, I had already turned down the plea. I had no idea that that was something I could take back after the fact. So this, and whether he can prove that or not at a hearing, I don't know. But it seems hard to me looking at this record to say it is conclusively clear on the record that he absolutely, it made no difference. And that's the standard, right? You say in your brief that the standard is, if it is not conclusively presented on the record that there was an issue, the defendant loses, but that's wrong. It's that if it's not conclusive on the record, then there has to be a hearing, right?
That is correct, Your Honor. And
Okay.
I feel
Mr. Bragdon, let me ask you a question about the, how is the restitution order and the guidelines restitution amounts different, or if they are?
Yes, Your Honor. Well, in the pre-sentence report, they calculated restitution and the loss amount to be the same, but they used two different standards to calculate those. And I will note that this court has already heard an appeal on direct appeal about the loss amount, and it affirmed the loss amount based on the appeal that came before it. That was objected to in sentencing. It was appealed before this court. This court affirmed. So that the restitution has absolutely no impact on the sentence, no impact on loss. It is a separate calculation. And if you'll give me a second, let me give the court the difference between the two legal standards. So when we consider restitution, the question in a case like this, where we're looking at where we're looking at a scheme or a conspiracy, the question is it part of the same course of conduct or common scheme or plan as the defense of conviction with respect to one of the elements? So that's the question for restitution. For loss, it can be an act taken in furtherance of a scheme, conspiracy, or pattern of criminal activity. Oh, actually, I'm sorry. I apologize. I reversed those two. The first one I gave is actually loss. So it can either be a part of the same course of conduct or a common scheme and plan. With restitution, it has to be in furtherance of the scheme or pattern that is specifically included as an element of the offense of conviction. And so the difference is really that any common scheme or plan is counted as loss. And so even if we say, even if it were true, to give the example of the United Global Investments, that was a scheme to defraud that occurred after Mayhew's initial indictment. So while he's on pretrial release, he commits a new fraud scheme. There's $298,000 that's part of loss and restitution for that. There is no doubt that that's includable as loss. Absolutely no doubt, because that's grouped for purposes of the sentencing guidelines. It's part of the common scheme and plan, and it's includable. For restitution, the defendant argues a different thing. They say, well, this is not a part of the scheme that was the offense of conviction. It's outside of the time frame. It's a different scope of conduct, and that may be true. That's not an issue the district court considered below, but that is an issue that only impacts restitution. If that's a mistake, it has absolutely no impact on the loss amount, which this court has already affirmed. It only impacts restitution.
Mr. Bragdon, I thought that part of the defendant's argument in this case was that part of the restitution amount included amounts for conduct on counts that either had been dismissed or on which he had been acquitted. Is that right? Do I have that right?
That's correct. And so the counts that were dismissed before trial were the United Global Investments counts.
Right. So is there any question that, a timely objection to those portions of the restitution order would have been sustained?
So let me split hairs a little bit, Your Honor. The counts that were dismissed at trial relating to McGrath and Fergus, those should have been included as restitution regardless, because they were a part of, they were conducted in furtherance of the scheme of fraud. And I just want to note, I can note a couple things in the record to identify that. If the court looks at the indictment, the wires are all within the time period of the conspiracy and the scheme to defraud with respect to McGrath and Fergus. There's no doubt that these acts are done in furtherance of the scheme to defraud. And when you look at the trial, that is not within the time period of our wire fraud scheme, our mail fraud scheme, or our conspiracy. And so I would not argue that if an objection was made, that $298,000 should not have been included as part of the restitution.
Okay, so if that's true then, so what are we to do about that, given the current posture of this case?
So I think if we look at the case law, when you look at 2255, habeas is limited to questions about being released from custody, issues that concern release from custody. 9 circuits have now come down and published decisions and said that an issue that's just financial cannot be part of a claim for habeas under 2255.
So just assuming hypothetically we agree, I just want to, just because our time is so short, can you get to the argument that, well, that's not all he's asking for here is relief from the restitution order. He's saying it affects his sentence, and so that would be cognizable, right?
Well, yes, Your Honor, and I apologize. I thought I was addressing that already by saying that restitution has nothing to do with loss.
So can I say one of my concerns, right, is that the district court he had a lot of claims in front of him, and so in addressing this one, he made this point with which I've asked you to assume, at least I agree, that this is not cognizable under 2255 because it's about relief from restitution orders. The district court never had an opportunity to consider this question about, well, what about the rest? Was there ineffective assistance as to the failure to object to the restitution order? Did that affect the sentence? Wouldn't it make sense for us to send this back at a minimum and let the district court take a look at that rather than trying to work that all out ourselves now?
No, Your Honor, for a couple reasons. The first reason is it is, I think, legally indisputable that loss and restitution are separate, and that the restitution as a matter of law, no matter how it's calculated, has no impact on loss. Second, this court has already affirmed based on loss, and the defendant did not bring a second separate case for loss. And third, I could be misremembering, but I believe the defendant did say that restitution and loss were related together in his habeas petition. I think he did make that argument. And the court rejected that when they said, this is just about restitution. It doesn't have any impact on this. And I would also point to the court to 3 cases that say, even if there's multiple issues, even if there's a claim that affects imprisonment and a separate claim that affects the financial side, the court will not consider the financial claim. We cited Kaminsky, which is a Second Circuit case in our brief, which states that issue. We cited Thiel, which is a Ninth Circuit case. And then I would also note Mamone is an 11th Circuit case that's not in our brief, but it's 559 F3rd 1209. And when you look at these cases, the Second and Ninth Circuit both said non-cognizable claims do not morph into cognizable ones by osmosis. And so they make the point that you can't turn a financial claim into an imprisonment claim just by adding an imprisonment element to it. The defendant has not.
So, Mr. Bragdon, if we assume that there was deficient performance, then the question is, when, if at all, during the process, is a defendant supposed to bring this claim? If he can't do it in a 2255 petition, when is he or she supposed to do it?
I do not have a conclusive answer to that question, Your Honor, but I will say a couple of things. The first thing I will say is that habeas that there obviously are opportunities at the time of the initial hearing and on direct appeal. Those were not taken here. Second, habeas is not intended to remedy everything. It's a limited remedy. It's focused on most important wrongs. And in doing that, the Congress specifically focused it on wrongs that relate to imprisonment. That's how they limited it. And so not everything can be done in that respect. The third thing I'll say is that some courts have looked at coram nobis as a potential remedy here. And I think if you had an unusual remedy, an unusual case where this was creating a lot of wrong, there might be a remedy that might fit it. The thing that I would say here is there's an over $2 million restitution. If the defendant made every payment required by the district court in over the course of his 26 years imprisonment and his 3 years of supervised release, he'll have paid less than $25,000. This is not a case where that $298,000 is likely to have any impact on him or the amount that he pays. And so I do not think it's an unusual or extreme case that needs a remedy. If it is, I think other courts have said, well, coram nobis may provide in an unusual situation a remedy to this case. I doubt that this case is that one. I think I did want to mention the Sixth Circuit is the only circuit that has said a restitution award can be brought in a habeas petition. And I wanted to note the situation in which they did that is somewhat unusual. There was a Sixth Circuit case that came out initially, and let me just get my notes. In 1995, there was a Sixth Circuit case called Watroba. And that case came out and said certain financial remedies, I think it may have been a fine in that case, cannot be brought as part of a habeas petition. Well, a number of other courts cited that and looked at that as they were considering this issue. In 2001, in the Weinberger decision, which the defendant cites, the Sixth Circuit in a footnote says, we're not going to apply that earlier case to restitution. And we realize that a number of cases have gone the other way on this. We recognize those cases, but we feel bound by a 1993 case in which we allowed restitution to be brought in a habeas case. And so that Sixth Circuit case does not really—
Mr. Brangen, before you run out of time here, I did want to bring you back to the first claim because of Judge Harris's questions regarding the timing of this and the context in which it appears. So I'm trying to think what an evidentiary hearing would provide us that we don't have already with respect to the assumptions that are being made here, right? The question is, first of all, did the lawyer provide deficient advice? And we're assuming that to be true for purposes of this appeal. And we've got what happened on the record at the hearing. And and maybe this is a question better presented to your colleagues on the other side, is what else could Mr. Mayhew present other than to say, obviously, that he would have taken the plea but for this deficient advice? And we just need to measure that against what the record evidence shows happened at that arraignment. Isn't that right?
Yes. And could I answer a little more fully?
Yes, please.
Okay. I do recognize I'm out of time, so I'll be brief. The one thing I'll say quickly is in our district, an arraignment serves the same function as a Rule 11 hearing. And so in our district, it's relatively unusual. My understanding is the warnings, the advice, a lot of that is the same, and arraignment kind of fills the function of Rule 11. And here, I think that, this was the defendant's chance to say, did he want to plead guilty? Did he want to go to trial? And I think if he had actually really wanted to take the plea, if he thought that this was a good deal, there would have been something said about that. And so I think the courts look conclusively about the sworn statements that defendants make. This is a sworn statement, and in that sworn statement, he both pleads not guilty and says that he wants to go to trial. The one other thing that I'll point to, and this is it's a part of the record, it's not part of the joint appendix, but docket entry 103 is a docket entry that discusses Mayhew's many complaints with his 4 other attorneys that appeared before this one, and how, and if you look at it, many of those complaints are very similar to the complaints he makes against Jeff Hosford. It makes it relatively clear that he wants to go to trial no matter what. And I recognize all of that would be appropriate at an evidentiary hearing, but I don't think the defendant has shown here that good advice would have made any difference in his decision, even enough to warrant an evidentiary.
All right, thank you very much.
Thank you. I ask the court to affirm.
Do my colleagues have any additional questions of Mr. Bragdon? Oh, okay. Ms. Augerson, you've got some time for rebuttal, and I may offer a little bit of time to Ms. Batchelor as well. So go ahead.
Thank you, Your Honor. I have 2 points on rebuttal. May I please support? First, addressing Judge Diaz's earlier question, on page 205 of the joint appendix, this includes Mayhew's motion under section 2255 that is akin to an affidavit and signed under penalty and perjury regarding Mayhew's belief and understanding that he had been told that he would receive a maximum of 5 years if convicted at trial. Second, opposing counsel argues that because Mayhew stated that he had the intention to go to trial, that this is sufficient to cure counsel's gross misadvice to Mayhew. However, as Judge Harris noted, an arraignment hearing is fundamentally different than a Rule 11 hearing. Mayhew was relying on his counsel's advice and was under the impression that his exposure at trial would be nearly equivalent to that if he took the plea agreement, making trial a very favorable option. Additionally, Mayhew did not even know that he was attending an arraignment hearing that day. He thought he was going in to discuss the letters that he had sent to Judge Fox. The arraignment hearing does not have a colloquy and did not provide this level of specificity or clarity that would have been provided at a Rule 11.
Ms. Augerson, can I ask you about that point? Is your point that he was just caught off guard and so we shouldn't hold it against him, that if he might not have been paying as rapt attention as he might otherwise had he been given notice that this was an arraignment?
No, Your Honor. It's not simply the fact that he didn't know that it was the arraignment hearing. That is not the sole point. The issue is that the Rule 11 hearings provide such a great level of specificity and a conversation back and forth between the judge and the defendant, ensuring that the defendant does in fact understand and responds to each question and each issue. Here, that is not what happened, which is fundamentally not part of an arraignment hearing. It was simply information told to the defendant, and Mayhew did not have any opportunity or was not expected to respond, ensuring that he understood fully the implications and the effect of the arraignment hearing that would happen at a Rule 11 hearing where if he had taken the plea offer.
All right, Ms. Augerson, let me stop you there. I'm going to give your colleague, Ms. Batchelor, an opportunity to say a few words before we end this hearing. Go ahead, Ms. Batchelor.
Your Honor, we would only add per the discussion of what available remedy there would be. If Mr. Mayhew did not have a 2255 motion available for him, we believe that he would be left without a remedy for the erroneous inclusion of the dismissed amounts.
Well, can I ask you about that? So is that really correct? I mean, I suppose we say often, and I think correctly so, that we don't normally consider ineffective assistance of counsel claims on direct appeal because it needs development of the record and the like, and that makes a lot of sense. But if a claim is where a claim is so obvious, there's so obviously deficient performance with respect to acquitted conduct that restitution could never be a part of that amount should never be a part of restitution. Why couldn't Mr. Mayhew present that claim on direct appeal?
Your Honor, the objection that was made both at sentencing to the restitution and was the objection that was to the restitution on direct appeal was about how the loss was calculated, and not, as you're saying, this very clear misinclusion of that loss. And so we believe that it was, especially on the charges that were dismissed at trial, it was on the motion of Mayhew's counsel that those charges were dismissed at trial, so he knew very well that those amounts should not have been included in restitution, and that's why we believe that it was objectively unreasonable conduct and deficient performance, which is again appropriate for an ineffective assistance of counsel claim. Yes, Your Honor.
No, I'm sorry, I didn't mean to cut you off. Go ahead.
Which this court has on repeated occasions held that a 2255 motion is the appropriate vehicle for an ineffective assistance of counsel claim.
I don't want to interrupt anything, but I just wanted to make sure that you would have a chance to respond to what I take to be the government's sort of main argument on this claim, which is even if the restitution order was higher than it should have been because of ineffective assistance, that would not have affected the loss amount at all. So there is no effect on the sentence. Did you want to respond to that?
Your Honor, the government in their brief on page 29 actually says that in this case, the loss amount and the restitution amount are essentially in this particular case, those two are the same, and that was how the court was using them and presenting them. And we believe that there is ambiguity in how the sentencing guidelines construe the loss from dismissed charges and their inclusion in for the purpose of base offense level sentencing. And accordingly, we think that in particular on this case, that the dismissed charges amounts do go both to restitution and the sentencing guidelines, and that the lack of objection to that was both in that it's not actually as clear of a distinction as the government is contending.
All right, thank you. Thank you, Ms. Batchelor. I want to join Mr. Bragdon in complimenting both Ms. Augerson and Ms. Batchelor on their presentations here this afternoon and in the briefs. You all are court appointed, and obviously we could not do the work that we do without talented lawyers, and in this case, student counsel being willing and able to present their cases before this court. You've done so ably, and I also want to thank Mr. Bragdon for ably representing the government in this case. We would typically come down from the bench and personally greet each of you. Obviously, we're not able to do that here today, but please know that you have our thanks and gratitude for a job well done. So thank you very much. You're welcome.
Okay, we're good to go now. Thank you so much. We're good to go now. Thank you.
Sarah, I don't see the lawyers up on the screen, so you just let me know when we're ready to do that.
Mr. Leonardi, can you turn your video on?
I attempted to, it was stopped. It says you cannot start your video because the host has stopped it. I'm on. Good afternoon, and may it please the court. My name is Dan Leonardi, and I'm appearing on behalf of Brian Williams. This case presents the question of whether a statute that permits a violation to be based on possession of 1 or more grams of crack cocaine is a controlled substance offense under the guidelines. Mr. Williams was convicted of being felon in possession of a firearm. He was not subject to the Armed Career Criminal Act. His guideline range, however, was based in part on prior controlled substance offenses. One of those controlled substance offenses we have objected to and is the basis for this appeal. That conviction was under 4453-375B. That provision of South Carolina law states that a person who manufactures, distributes, dispenses, delivers, purchases, or otherwise aids, abets, attempts, or conspires to manufacture, distribute, dispense, deliver, or purchase, or possesses with intent to distribute, dispense, or deliver methamphetamine or cocaine base in violation of the provisions of section 4453-370 is guilty of a felony. Although this court has addressed that provision of 4453-375 in the past, I don't believe it has had occasion to address the specific provision at issue in this appeal, which is the provision after the provision I just read and after the penalty provisions, which states that possession of 1 or more grams of methamphetamine or cocaine base is prima facie evidence of a violation of this subsection. Prima facie evidence is defined as evidence that will establish a fact or sustain a judgment unless contradictory evidence is produced. In other words, it's enough to sustain the conviction. The conviction at issue here is at paragraph 35 of the pre-sentence report. That's at page 117 of the joint appendix. Mr. Williams was originally charged with trafficking, and the indictment specifically charged, among other conduct, that he did knowingly, actually, or constructively possess more than 10 grams, but less than 28 grams of crack cocaine. That's at the joint appendix at page 134. He did not, however, plead guilty to the indictment. He pleaded guilty to a violation of 4453-375B. There is one Shepard document in the record. It's on the following page, joint appendix 135. And we submit that it is ambiguous because it reflects both that Mr. Williams was convicted of PWID crack cocaine, that is handwritten in, and also that he was convicted of a lesser included offense of the charge in the indictment. Looking at the government's brief in this case, it would appear in footnote 7, this is on page 13 of the government's brief, that the government concedes that PWID is not a lesser included offense of trafficking based on the elements. And the Shepard document is, in fact, ambiguous.
Counsel, did you raise this argument before the district court that it's not clear that your client actually pled guilty to possession with intent to distribute?
Your Honor, in reviewing the record today, it did not appear that it got that far. The argument did not get that far at the district court level.
Okay.
And I think that the fallback argument and the argument that was made at the district court level, and I think it still holds now, is that regardless of which of the, assuming that we are, assuming in light of furlough, I know that furlough has been vacated, but in light of furlough, and these briefs were written when furlough was still had not been vacated yet, regardless of what the individual crime is, if in fact the violation can be based on possession of 1 gram of cocaine or methamphetamine, then it's not necessarily, it's not important what specific crime it was. This provision is not—
Mr. Leonardo, how does a clerical error make what your client pled guilty to ambiguous? I mean, he pled guilty to possession with intent to distribute a drug. And there's obviously a clerical error, but how does that create an make it ambiguous as to the fact he pled guilty to PWID?
Well, Your Honor, I don't know that we can conclude that he did in fact plead guilty to a crime that has the elements of PWID. In this case and in the briefing, the government has not set forth what the elements of PWID in South Carolina are. And what we've argued is that this special provision of this statute sets forth alternative elements that can lead to a conviction. So Mr. Williams may very well have walked into the courtroom and admitted that he possessed 1 gram or more of cocaine base, and that would have been sufficient to sustain the conviction under this provision.
Counsel, can I just ask you a question about the form, though?
Absolutely.
Because I've actually been seeing this pop up a couple of places. So in your view, assuming he did, in fact, plead guilty to possession with intent to distribute crack cocaine, as is written out on the form, what box was supposed to be checked? Were they supposed to check defendant waives presentment to the grand jury on the theory that he had, in fact, waived? Like, what box do you think they should have checked? If it's not a lesser included offense, it's not what he was indicted for. So is this here to ensure that before you plead guilty to something, you've either been charged with it in your indictment or you have waived presentment? Is that what's going on? I'm just trying to figure out.
Yeah, I don't know that I can answer the question definitively. I don't know that in every case one of these boxes needs to be checked. It may be the case that it's possible for a defendant to plead guilty to something that is in fact not a lesser included offense or in the indictment if it is otherwise set forth on the sentencing sheet. Here, it is handwritten, and we don't deny that it is handwritten here, possession with intent to distribute crack cocaine, first offense. Just as an analogy, in the Brandon case, Mr. Brandon, the North Carolina case, was convicted of trafficking. So if he's convicted, it's called trafficking, and so we would submit that to the extent, even if you were to conclude that he was convicted of possession with intent to distribute crack cocaine, as is reflected on that two field, that doesn't necessarily mean, because of this special provision of the statute, that there was an element of that offense of intent to distribute.
I just have one last question about the form and then I'll stop. If you're right about this argument that because of the prima facie evidence provision, you could be convicted of possession with intent to distribute based simply on possession, then doesn't that mean that, in fact, possession with intent to distribute is a lesser included offense of trafficking? I mean, aren't your two arguments inconsistent? I thought the whole point of your argument that it's not a lesser included offense was because possession with intent to distribute requires intent to distribute, which you don't need in trafficking. But the whole point of your second argument is actually they're the same thing because you can be convicted of either one just based on possession. So which argument do you want to go with?
Well, I think that both of them can be proven, or somebody can be convicted based on possession alone. So to the extent that that means that it is a lesser included offense, there's still not the element of intent to distribute. It's possession alone, and so the conviction would not count. Turning to, so as I was explaining, even if the court concludes that Mr. Williams was convicted of a crime called possession with intent to distribute, the Brandon case addressing North Carolina's trafficking case is very instructive here. In that case, the court acknowledged that the common sense definition of trafficking included regular buying and selling, just as the common sense you would think that possession with intent to distribute would necessarily include an intent to distribute. But the court, this court in the Brandon case ignored that and said it may very well be that North Carolina was considering the fact that the common usage of that term trafficking means that a person did intend to distribute it. But that's not made an element of the offense in the statute. And so we would submit that also in this case it is not made an element of the offense because it can be proven by possession alone. Certainly, the General Assembly could have set forth in this statute that possession of 1 gram or more constitutes evidence of a presumption of intent to distribute. And in fact, an adjacent subsection of this very statute, subsection D, indicates that possession of manufacturing equipment gives rise to a presumption of intent to manufacture. This provision is different. It does not link to any particular element. It is linked to, quote, a violation.
Mr. Leonardi, can I ask a question? And you may have touched on this earlier and I missed it, but of course we don't have the plea colloquy in this case. We don't have a transcript of exactly what was said or not. But if I understand your argument correctly, you're saying that a defendant in South Carolina could admit to a judge that I possess a certain amount of, in this case, cocaine over the amount that establishes the statutory inference of possession with intent, never admit an intent to distribute, and that alone would be enough to convict or accept a plea of guilty. Is that right?
Your Honor, based on the plain language of the statute, I don't know that we can say that it would not be accepted, just as in North Carolina, an admission of possession over the threshold amount would result in a conviction for trafficking.
I mean, I would imagine, though, that the judge in a plea would recite the elements, but I suppose if he didn't want to admit the element of intent, then a judge could still be within its rights to accept that plea is fully supported by the facts based on the statute.
That's exactly right. And that's exactly right, Your Honor. And in the Furlough case, of course, there was a plea transcript. Essentially, I guess the gold standard of a Shepard document, because it sheds so much more light on what specific crime, assuming you have a divisible statute, the defendant was convicted of. But we don't have that here. We have one Shepard document. Certainly, as this court has seen in cases in the past, the South Carolina sentencing sheets sometimes leave much to be desired in terms of their clarity. And that has resulted in, I understand, many cases coming to this court on appeal regarding the South Carolina statutes. Because Mr. Williams could have been convicted based on possession alone, and for all we don't know what happened at that plea colloquy. And it may be a totally different situation if we had a plea colloquy or other Shepard documents that shed light on it. But since we...
Counsel?
Yes, Your Honor.
So and maybe this is why we're talking about a plea and not a trial, because it seems like the jury instructions, the standard jury instructions are very clear, right? That this is just a permissive inference and it doesn't relieve the state of the obligation to prove intent. And the jury's still going to have to find intent beyond a reasonable doubt. Would that not transfer over to I mean, I assume the same would be true when a judge takes a guilty plea, right?
Well, Your Honor...
I'm just having trouble squaring your reading of the statute with all of these pattern jury instructions, I guess is my question.
I understand the question, and I have seen pattern jury instructions that specify that this does give rise to a presumption. I know that is not in the briefing, and that may be because that the South Carolina Supreme Court has removed the jury instructions that used to be the ones that were kind of the ones that everybody went to determine what the pattern jury instructions were. So I don't know what pattern jury instructions are being used now. I know that I have seen in the past pattern jury instructions in South Carolina that have set forth that this provision gives rise to a presumption of an intent to distribute. Of course, we submit that is in conflict with the plain language of the statute.
Yeah, I'm looking at one that says this permissive inference does not relieve the state from actually proving beyond a reasonable doubt the element of intent to distribute. But I mean, right, so, but you're saying to the extent the instructions say that, it's inconsistent with the language of the statute.
That's correct, Your Honor.
Okay.
And for that reason, we believe that this conviction should not count as a controlled substance offense, that his base offense level should be lower, and the case should be, the conviction should be vacated and remanded for resentencing.
Thank you, Mr. Leonardi. Ms. Flynn, we'll hear from you. I don't know if you're speaking, Ms. Flynn, but we can't hear you.
She's on a Polycom. Let's give her just a second.
Can you hear me now?
Yes.
My apologies.
It's like a
May it
bad
please-
wireless telephone commercial.
May it please the court. My name is Catherine Hollingsworth Flynn, and I represent Appellee United States of America in this matter. Your Honors, 3 things are clear in this case. First, Mr. Williams's underlying conviction was for possession with intent to distribute crack cocaine under South Carolina 4453-375B. Second, a conviction for South Carolina PWID under that statute requires the state to prove beyond a reasonable doubt an intent to distribute. And third, South Carolina PWID under that statute is a controlled substance offense under Section 4B 1.2 of the Sentencing Guidelines. Because those 3 things are true, the district court did not err in enhancing Mr. Williams' sentence under Section 2K 2.1A2 of the Sentencing Guidelines, and this court should thus affirm the district court. Your Honors, there was no error, clear or plain, in the district court finding Mr. Williams' 2003 conviction was for PWID crack cocaine. The government bore the burden at sentencing to show by a preponderance of the evidence the facts underlying that prior conviction that supported the sentencing enhancement. Under the higher clear error standard, substantial evidence supported the district's court finding that Mr. Williams' conviction was for PWID crack cocaine. As this court has previously ruled.
Ms. Flynn, can I ask a question? So if the defendant in this case had appeared before the trial judge and the court had read off the elements of the PWID offense that you just talked about and read the statutory inference that applies in this context, and the defendant had said, well, Your Honor, I admit that I possessed 2 grams of cocaine in this case, and that's all that I'll admit. And the court then looked at the statutory inference and said, that's all you need to admit. Your guilty plea is accepted, and that's the colloquy that we have in front of us. Would you concede that that offense, applying the modified categorical approach and looking at the facts of that colloquy, that would not be enough to make this a controlled substance offense?
Your Honor, I think the language of the statute is clear that prima facie language is an evidentiary presumption. It does not negate the state's requirement to prove beyond a reasonable doubt the elements of the offense, which are possession and intent to distribute. So if that
so if the state in this case in a contested trial had relied solely on that evidence to prove guilt and the state had moved for a directed verdict, you think that directed verdict should be granted?
If all the state had proved was possession?
Yes.
I think that if the fact finder could not find beyond a reasonable doubt that there was intent to distribute, then that conviction could not be sustained, Your Honor.
So the court should grant a directed verdict in that case, is what you're saying?
To the state?
You're saying, or to the court? Defendant? To the defendant.
Yes, Your Honor.
Well, and I don't mean to sandbag you here because I don't know that, I don't think this case was cited by either party, but there is a Supreme Court case called Johnson versus State on those very same facts, and the site is 480 Southeast 2nd, 733, where the court denied a motion for a directed verdict by a defendant on the ground, on facts that showed simply possession. The court said that possession alone, given the statutory inference, was enough to allow that case to go to trial. So I'm having a bit of trouble then understanding if that's the state of the law, how we can say that this is a controlled substance offense sufficient for purposes of the enhancement.
Your Honor, I think, again, that the evidentiary presumption is just that. It is merely an evidentiary presumption. The state must prove intent to distribute as well as possession in order to sustain a conviction, either a plea or at trial for PWID. And I have not seen the case that Your Honor is citing to,
No,
so
I
don't
understand.
know the specific
I don't-
facts underlying.
Sure, I understand. So go ahead. But I mean, read literally, that language in the statute seems to suggest more than an inference. It seems to suggest that possession alone, and it is odd because it would seem strange that that would be enough, but.
And I would agree with Your Honor that it is odd language, but I think we have both from this court and from the South Carolina Court of Appeals and Supreme Court cases that support the idea that this is a permissive inference that does not negate the state's obligation to prove beyond a reasonable doubt that element of intent to distribute. In this court in Marshall, this court found that South Carolina PWID marijuana and PWID marijuana within proximity of the school both involved an element of intent to distribute. While Marshall concerned different subsections of statute than are at issue here, specifically subsection 370A1 and 445, those statutes track the same language as the statute at issue in this case, 375B. In this court, in the Furlow opinion, on page
Ms.
320.
Flynn, can I, sorry, I didn't mean to interrupt, but so let's talk about what that language permissive statutory inference means. It would seem to me that what that suggests is that if a jury or a finder of fact could rely solely on the quantity of drugs involved in a particular case and find solely based on that quantity that that's inconsistent with personal use, more consistent with an intent to distribute, and that evidence alone, based on the quantity of the drugs involved, would be enough to convict. You don't think that's a reasonable inference in a case that a jury could make?
I don't think that is the statutory language and what the statute requires in South Carolina. I think that it is an evidentiary presumption, but I don't think it negates the element of the crime.
So it doesn't matter how many. Go ahead, Judge Harris.
No, you go, Judge Diaz. Oh, no. Judge Diaz, you might be on mute.
Oh, I am, sorry. So, and I don't mean to beat a dead horse, but it doesn't matter in your mind what the quantity of drugs that's involved. The state has to present something more besides quantity.
In order to sustain a conviction for PWID under 375B, yes, the state must present that additional element of intent to distribute. Okay. I think that under the South Carolina, my apologies.
No, I'm sorry, because I just wanted to make sure I understood. So you are not just saying that under South Carolina law, the jury has to find beyond a reasonable doubt intent. You are saying that cannot be based on quantity alone, even if the person has, I don't know my numbers, but 1,000 kilos of a controlled substance. You're saying that prosecutor cannot go into court and say, come on, obviously distributing. There's going to have to be something else?
Correct, Your Honor. I don't think possession alone meets the state's burden to prove PWID under 375 in South Carolina. And I think the South Carolina Court of Appeals and Supreme Court cases are instructive in this regard. They tell us that 375B, this prima facie language we're talking about, creates a permissive inference, but that a conviction for PWID does not hinge upon the amount involved. The Court of Appeals in James specifically said that the language we are talking about creates a permissive inference that possession of more than 1 gram of crack cocaine constitutes PWID, but a conviction of PWID does not hinge upon the amount involved, and then went on to say that possession of any amount of controlled substance coupled with sufficient indicia of intent to distribute will support a conviction for possession with intent to distribute. And that is State versus James, which is cited in the briefs, State versus Robinson, and State versus Brightman, also cited in the briefs, support that same concept that possession alone is not sufficient to sustain PWID. You must meet that element of showing intent to distribute.
Can I ask you just another question about the statutory structure, which I'm struggling with? So this prima facie evidence provision applies to the entire subsection. So how would it work if you applied it to the first subsection of B? So say someone was being charged with manufacturing a controlled substance or methamphetamine. Is it still the case that possession of 1 or more grams would be prima facie evidence now of manufacturing? That just seems so odd.
And Your Honor, I'm glad you asked that question, because I think that is exactly one of the problems with the argument that appellant is making here, is that that argument conflates possession, trafficking, and PWID, and makes possession the basis of all of the violations in 375B, all of those potential crimes. And it cannot be that manufacturing or distribution are possession alone offenses, that the state need not prove more to sustain a conviction for manufacture or for distribution. 375B, as this court has recognized, contains multiple crimes with different elements. It criminalizes various types of conduct, but it explicitly does not criminalize mere possession. The South Carolina legislature knew how to criminalize mere possession. It did that in subsection 370C. And the South Carolina legislature also knew how to make possession the basis of a violation, possession of a threshold amount. We need not move far from the statute at issue in this case to get to precisely where the South Carolina legislature did that in 375C, where felony trafficking is defined as possession of a threshold amount. That is all the state needs to prove for trafficking. Possession with intent to distribute is a different offense and requires proving intent to distribute. Frankly, the 375C trafficking statute is the statute that is analogous to the Brandon case raised in appellant's brief. And like that statute at issue in Brandon, the North Carolina trafficking statute, a violation of that statute is proved by possession of a threshold amount. And the difference between that and PWID under 375B in South Carolina, PWID requires the intent to distribute element. And that is why the Brandon case does not decide this case. In addition to the South Carolina cases, holding intent to distribute is an element of PWID. As I said, this court found in Marshall that PWID under two different but related statutes involved an element of intent to distribute. And this court noted in Furlow on page 320 of that opinion the similarity between the statute at issue in Marshall and the statute at issue in this case, and said that for our purposes, the sole distinction between the Marshall statute and this statute is that the former applies to all controlled substances and controlled substance analogs, while the latter specifically concerns methamphetamine and crack cocaine. Thus, the Marshall holding is instructive for the holding regarding the statute at issue in this case.
Counsel, can I ask you just a quick question? It's to clarify in my own mind. So I've seen all the cases and the jury instructions and everything saying that intent to distribute is indeed an element that must be proven beyond a reasonable doubt for PWID. But that seems to me to be there seems to be some space between that and saying, and you can't prove it by reference to quantity of drugs possessed alone. But you are saying both things. It's a separate element. It has to be proven. It is not conclusive. It's not that if you're caught with whatever it is, 1 or more grams, it's conclusive. Absolutely. That counts as distribution. I think it is clear that the case law says, no, intent to distribute, you need the intent as a separate element. But you are also saying, and that element cannot be proven under South Carolina law by reference to the amount possessed alone.
That is correct, Your Honor. I think that is what the South Carolina cases say. I think that there may be possession with intent to distribute of less than a gram. In fact, if Your Honor looks at the facts in this case as delineated in the PSR, Mr. Williams, the factual basis that led into his federal charge involved distribution of less than a gram. And then while on bond, he engaged in 2 additional controlled buys of less than a gram.
Counsel, is there anything in the legislative history that explains what this provision is doing here? Was there an argument being made that, the only thing I can think of is it possible that there was an argument being made in some of these cases that the prosecution can't rely on the quantity of the drugs possessed, even in combination with other factors, to show intent? Like, you're just not allowed to allude to the quantity at all? Is that what this is here to say? That, like, look, you have to prove intent, and you are allowed to rely in part on the amount of the drug that was possessed?
Your Honor, I think the South Carolina cases tell us that intent to distribute is a separate element that must be proven for this offense, that the amount involved alone does not prove that element.
Ms. Flynn, I don't want to rain on your parade, but if you are charged with possession with intent to distribute, the jury, first of all, you have to prove possession. Second, you have to prove intent. One of the ways that you can prove intent is by using that permissive inference. And so I don't, if there's no other evidence other than that permissive inference, a defendant can still be found guilty in South Carolina.
And Your Honor, I would say that the jury instructions are going to say there is this permissive inference. However, the state must still bear the burden to show beyond a reasonable doubt both possession and intent to distribute. And
it is the thing that you're proving beyond a reasonable doubt is the inference. You tell the jury you may infer that if there's this quantity, there is intent to distribute. Now, they don't have to accept that, but they often do, and that's all the evidence they got, is there was possession and there was this amount of drugs, and the state over and over uses that inference to prove the case. Because you often, for example, you find somebody riding down the road and they have the drug in their hands and they have the amount to meet the permissive inference and there's nothing else. I can promise you, I've seen convictions.
And Your Honor, I would say that, again, the instruction would be that you are required to prove beyond a reasonable doubt that intent to distribute. And I do not believe that the permissive inference language specifically says this amount is evidence of intent to distribute.
It's an inference upon which a jury or a judge taking a plea can find beyond a reasonable doubt intent to distribute. It doesn't have to be anything more than that drug weight.
It is a permissive inference allowing of evidence of violation of a subsection, and that subsection encompasses far more than PWID as previously discussed. And so, Your Honor, we would say that the sentencing sheet in this case shows that Mr. Williams pled to 375B, pled to Pee-wee crack cocaine. The CDR code, the South Carolina statutory code, is consistent with that. And in sentencing, Mr. Williams never contested that his conviction was for P-Wade crack cocaine, and the government several times put forth the argument, Your Honor, I think that there is no argument here that Mr. Williams was convicted of P-Wade crack cocaine.
Counsel, I mean, I agree that it doesn't look like it was raised below, but can you just tell me what's going on with this sentencing sheet? Why did they check lesser included offense? What should they have checked? What's going on here?
But I do not think that undercuts the preponderance of the evidence that the government met at sentencing to show that conviction.
I mean, I think that might be right. I would just say that I've seen a bunch of cases recently where, much like this, where lesser included offense is checked, and it probably shouldn't have been. And I just wonder what's going on. And maybe someone should do something about this, because this may not be the right case to get to the bottom of it, because I don't think it was raised below, and so the district court didn't have a chance to address this. But I am sort of concerned, and both that just questions are going to keep coming up, perhaps needlessly, if this is just a clerical error, that perhaps people are supposed to waive presentment if they're about to plead guilty to something for which they haven't been charged and they're not. So it just seems like maybe someone ought to sort this out. I don't know if you're in a position to do that, but I just raise it as a concern that maybe could be taken to someone in a position to try to figure out what's going on here, because this is coming up an awful lot these days.
I understand that concern. May I have a moment just to finish out my argument, Your Honor?
Well, you can respond to Judge Harris's concern and briefly wrap up.
Certainly. Thank you. Your Honor, I agree. I think that this sentencing sheet may have a clerical error. I do not think that what Mr. Williams pled guilty to is ambiguous. I do not think that the government did not meet its burden. And I think there is substantial evidence showing that Mr. Williams in this case pled guilty to P-Wade crack cocaine, because that crime under South Carolina law requires showing both possession and intent to distribute. I think it qualifies as a controlled substance offense under the guidelines, and therefore we would ask this court to affirm the district court.
All right. Thank you, Ms. Flynn.
Yep.
Mr. Leonardi, you've got some time for rebuttal. Could you start with the question that Judge Harris asked about this statute, which is strange in a great many ways, but not the least of which is that she pointed out that sort of presumption or statutory inference makes no sense in the context of the other ways in which you can violate the statute. Frankly, when I read it, I just assumed that the legislature was focusing in on possession with intent to distribute, and that's where the inference logically should apply, but it doesn't seem to. I suppose you could read it differently.
Well, I agree that it seems to more naturally fit with some of the specific means or crimes delineated in the statute. I think that it could fit with purchase. That's one of them. Somebody in possession of this quantity of a controlled substance could be charged as that they purchased a controlled substance, and this provision would make more sense in that context. I know that in the Brandon case, at the end of the case, this court talks about that the presumption that the government argued for there could be associated both with manufacturing or distributing. So the quantity there, they said, could lend itself perhaps, or at least the government argued, would lead to a presumption of manufacturing. I have to acknowledge the statute is maddening on several levels, and it doesn't appear that this particular provision fits naturally with all of the various crimes that are delineated there. But it does appear to work with several of them, and the plain language of this provision, and that's what I'd like to refocus on in closing, it does not mention a presumption, and it is not associated with any particular crime. It says a violation, so it refers to the entire subsection. And when we look at the teaching of Brandon, the fact that it doesn't have a connection to any crime and it doesn't mention presumption, should we interpret it as having that, even though it's contrary to the plain language of it? Should we interpret it that way? In the Brandon case, which dealt with a threshold amount of 28 grams, this court went at length about how 28 grams is not a reasonable amount that should lead to a presumption of distribution or intent to distribute or anything like that. It's simply not enough. And in this case, the threshold.
Counsel, can I, because this will help to clarify it for me, but in Brandon, if I'm remembering right, intent to distribute was not a statutory element. It didn't have to be proven to the jury, didn't have to be found beyond a reasonable doubt. So just hypothetically, what if I think that the best reading of this provision is that this case is different from Brandon? You have to prove intent beyond a reasonable doubt, and the fact of possession of 1 gram or more is not going to relieve you of that burden. You're not allowed to say you don't have to find intent. It's still an element that has to be found by the jury. But if the jury wants to, it can find beyond a reasonable doubt that there was intent to distribute based only on the amount of the drug in question. If that's the situation, it's still an element that has to be found beyond a reasonable doubt, but what evidence the jury uses to find it might boil down to the quantity of the drug. If that's what's going on, is that a categorical match or not? Because I could understand an argument that that's still a categorical match, because that's a very formal inquiry. We just look at the elements, and if the elements match up, we're fine. And now intent is an element, and who cares how the jury, what the jury relies on to find it? All the categorical approach asks is, you know, is there a match between elements?
The answer to that, Your Honor, in all candor, is yes, that would be a categorical match. In this instance, we argue that it does not give rise to that presumption. And I know, and certainly the government's best arguments here are based on the jury instructions that you mentioned, Judge Harris, and the South Carolina cases that in dicta, not really being confronted with what...
Mr. Leonardi, I'm sorry, what does a presumption have to do with it if in fact it's a categorical match? I'm not following that.
I understood the question to be, if it does give rise to a presumption and a jury would have to find the element of intent to distribute, if that is the case, is it then a categorical match? And my answer to that was yes, if it does give rise to that presumption and the jury is still required to find an intent to distribute, which we submit is contrary to the plain language of the provision that I've been focused on.
All right, so your argument turns on, your argument is intent is not an element of this crime. The jury does not have to find intent to distribute beyond a reasonable doubt.
That's exactly right. The offense is called PWID, just as in Brandon it was called trafficking, but the element does not exist because of this clear statutory language. And without statutory language that invites, that says that there is a presumption, or says that this is a stand-in, this provision is a stand-in for PWID, one of the crimes delineated above, assuming that the furlough analysis is accurate. Then, in that instance, we look at, is it reasonable for us to then impose to create an inference there? And in light of the threshold amounts and the teaching of Brandon, we would argue that it's not reasonable. And this is
Mr. Leonardi, so let me ask just one additional question. So in either case, whether it be a guilty plea or a jury trial, South Carolina judge in reciting the elements of this offense would have to recite at least two elements, right? A possession of a certain amount of, well, not even a certain amount, possession of narcotic that fits within the statute, and intent to distribute. So are you saying no, that's not the way it would work?
That's exactly right. We're saying that the judge would have to, instruct on the plain language of the statute, which is that you can find these elements delineating the normal elements of possession with intent to distribute, or there's a shortcut, essentially. Or you can base your conviction on the portion of the statute that states that possession of 1 gram or more is prima facie evidence of a violation of the subsection. If that's the case, then a jury could find, based on evidence of possession of 1 gram or more, that a violation is present and then the person is convicted. So in that instance, they would not need to find the element of intent to distribute.
Okay. Either one of my colleagues have any additional questions for Mr. Leonardi?
No, sir.
All right. All right, the case has been submitted. Thank you both, counsel, for your arguments here this afternoon. We appreciate your being here under very unusual circumstances, and we would typically come down from the bench and greet you personally. We can't do that here, obviously, but we are grateful nonetheless for your helping us in resolving this interesting case. And with that, the court stands adjourned sine die. Madam Clerk.
The Honorable Court stands adjourned. Sine die. God save the United States and this honorable court.